All rise, please. The court is now in session. Number 20, please come up to the podium.
It is beautiful out there, just in case you haven't been. I'm sorry. Sorry I'm late. I'm never late. But I am today, so sorry about that. All right, number 20?
Yes, Your Honor.
Yes, Your Honor, please.
All right, let's see.
No court reporter, Judge.
All right, we're here on La Consulate versus Royal 18-14105. Let me have appearances, please.
Your Honor, Yamila Lorenzo on behalf of the plaintiff.
All right.
And Alexander Orlovsky on behalf of the defendant, Your Honor.
Okay. All right. It's plaintiff's motion, so let me hear from you. Or unless you all have reached an agreement in the extra time that I gave you by being late. No?
No, Your Honor.
Okay. All right. Talk to me, please.
Your Honor, final judgment on this case was entered January 15th.
Okay.
And in that order, it said within 45 days, Form 1.977 was to be entered. That form was due March 1st. The form was never done, was never filed with this court. Instead, defendant filed a protective order stating that Royal Flush Management is a dissolved company and doesn't have agents, owners, or records. That's a little hard to believe because then who do they represent? Who are they here for? Who's paying their bills? And defendant's now stating that Royal Flush is owned
Hopefully
by this.
somebody's paying opposing counsel's
hope
bills.
so.
It's been a while, Your Honor.
All right.
Defendant's now saying that it's owned by Zilkator, but that's a red herring. There's no document that says Zilkator actually owns Royal Flush. There's a management agreement that basically is between Zilkator, Royal Flush, and this other company, but the management agreement says that Royal Flush is managing the other company, not Zilkator managing Royal Flush. Your Honor, we're just asking that defendant fill out this form, and we're asking, excuse me, and we're asking for a contempt order.
Okay.
Your Honor, this was the case that it's been in front of you a couple times with my associate, where the main company, Zilkator, is in an ABC proceedings in front of Judge Thornton.
In front of who?
Judge Thornton in the complex, Judge Thomas, I'm sorry.
Okay, all right.
Sorry, it's been a long morning already. And this is the case, and plaintiff's claims, they have two, and the law firm also has another case. Both their claims and my firm's fees are in the assignment for the benefit of creditors. And under the assignment statute, and this was in front of the court, I think on the motion for summary judgment, the court held that it wasn't enough to stay the case, but that he would need to file a claim in the assignment for the benefit of creditors. I asked counsel this morning if they've done that. This claim is on the assignment for the benefit of creditors. My firm's fees are. There's millions of dollars of monies that are owed to various people. In that case,
I understand, but that doesn't stop you. They're two different things. One is collecting, the other one is filling out the information in the form. So.
Well, Your Honor, the problem is I no longer have a client to sign. I've requested the documents, the tax returns, and the bank statements from the assigner. And as soon as I get them, I'm going to give them to him, to the plaintiff's
So
counsel.
tell me, what are we talking about?
I would like 10 days to try and get the documents. I've called them twice yesterday, and they haven't called me back yet. My clients no longer exist. We're going to be filing a motion to withdraw, but I'm going to try and at least get them the tax returns and the bank statement.
All right, I tell you what, you got the 10 days. I'm putting this on the calendar 2 weeks from today.
Okay.
So do me a favor, do a notice of hearing for 2 weeks from today. Let's get it done.
I'll get everything in.
It doesn't matter. I mean, even, hopefully you'll get paid, but I'll see everybody. What's the date on that?
What's your name? Sorry?
So April 2nd, 4/2 at 9:30.
Thank you, Your Honor.
Your Honor, will there be fines for failing to...
There may be. I mean, I'm issuing a rule to show cause. It's returnable on that date.
Okay.
Okay, so,
Thank you.
all right, thank you all.
Have a good day, Your Honor.
You too. Say hi to Judge Thomas.
Judge, we don't have anybody else.
What?
We don't have other teams.
All right, well then let's just start calling, the cases. You know what? There's somebody on court call on Cohen versus Dream Builders 7, 8, 9. Anybody here on that?
What's the number, Your Honor?
It's number 7, 8, and 9.
There's a defendant check. Who's number 7? I said defendant. Somebody checked in.
Okay. All right, because I think somebody's on court call. Well, we'll wait as soon as they get back.
I don't know.
All right.
Please, that's for number 7 here. Thank you.
All right. What else? Anybody else have stuff that we want to get to?
Sure.
All right.
Number 17.
17.
Elena Vivas on behalf of the plaintiff Neda Yerena. This is defense's motion to compel appraisal. Should we wait?
And you're the
We're number
defendant?
7.
Plaintiff.
We were outside waiting
Oh.
for
And actually, I'm here for number 17 as well.
Okay, perfect.
Perfect. Excellent.
I'm for plaintiff.
Right. You're for plaintiff?
Yeah.
Okay.
Phil Guzek on behalf of the defendant, Your Honor.
Okay. All right. What's this? Do we have a trial date set?
I believe we did for this one.
We don't, Your
Okay.
Honor.
All right. Talk to me about when we can, take and schedule the depots.
I think we're on defendant's motion to compel appraisal. 17.
No, 17?
Yeah.
Can't be 17 then. Oh, 18. You're
18.
right. Close.
Close.
Wait, we have a court reporter number 18, Your Honor.
Okay. Are you ready? Almost?
So you're not 17, you're 18?
They're 18.
Yes.
Okay, thank you, ma'am.
All right. You ready? We're here on Urena versus Citizens, 18-11832. Let me have appearances, please.
Elena Vivas on behalf of the plaintiff.
All right.
Phil Guzek on behalf of the defendant.
Okay. All right. It's your motion, so let me hear from you, please.
Yes, Your Honor. We're here on the defendant's motion to stay and compel appraisal in response to the plaintiff's complaint, Your Honor. The defendant invoked appraisal pursuant to the terms and conditions of its policy, which allows for alternative dispute resolution, namely appraisal. Your Honor, I think you've heard this in numerous times before. Defendant is of the position that...
It's new each and every time that I hear it.
It's as if it never occurred before.
Right.
The defendant is of the position that it is entitled to invoke appraisal in response to the lawsuit, and specifically cites to Florida Insurance Guarantee Association versus Castilla 18 Southern 3rd 703, which stands for the proposition that an insurance company, even though it did not invoke appraisal pre-suit, can do it in response to a complaint. I think the plaintiff's main objection, at least in terms of the response that I read, were that the defendant had somehow waived its right to appraisal by filing a motion to dismiss, Your Honor. We did file a motion to dismiss and strike certain allegations in the plaintiff's complaint, but the defendant's of the position that that is not a waiver of its right to invoke appraisal under the policy, because the specific motion to dismiss was just an allegation that the plaintiff's allegations as pled were impertinent and scandalous. Your Honor ended up denying our motion to dismiss, but that does not in and of itself waive our right to invoke appraisal just because we said, plaintiff's complaint the way it is.
Well, refresh my recollection. Was it because of bad faith allegations?
That's correct,
Is that what the...
that was the allegations in the motion to dismiss, Your Honor.
Gotcha. Okay. All right.
Your Honor, we filed suit on April 12, 2018. The defense filed their responses to discovery, their privilege log in August of 2018. It wasn't until December 12th, I believe, that the defendant actually invoked appraisal. We've already started litigating this case. It's 275 days after we filed the complaint that now they want to go to appraisal. So at this point, we've already begun litigating the matter. We can agree, or we would ask the court to send this matter to mediation.
So long as I reserve on attorney's fees.
Right. Mediation, instead of making our client spend thousands of dollars on an appraiser and an umpire, we could probably amicably work this dispute out at mediation, and the court can reserve, the defendant can reserve their right to go to appraisal if, in fact, we can't resolve it in mediation.
Okay.
So very briefly, Your Honor, we filed our answer in affirmative defenses on December 12th, 2018 because of the pending motion to dismiss. So that's just in response to why it took so long in order to invoke appraisal in its answer in affirmative defenses. In terms of mediation, Your Honor, appraisal is already addresses a fair portion of what the dispute would be between the parties. If Your Honor were to order us to mediation, I just ask that it wouldn't necessarily, if the mediation is unsuccessful, it wouldn't necessarily hinder the defendant's ability to continue to attempt to invoke appraisal.
And we can agree on that.
All right. Here's what I'm going to do. I do find that appraisal has not been waived under the circumstances of the case. I am going to grant the motion to stay and compel appraisal, and I am going to reserve on attorney's fees. Okay?
Thank you, Judge.
All right.
Thank you.
Judge, we go ahead, Victor, we go ahead and do number 7 right now.
Yes.
With the other, with this, Court call, Your Honor. Thank you. You can move a little closer since we court call.
Please remain on the line.
No,
and
that
a call
belongs to
or a conference operator will be with you shortly.
Should we move these?
Yeah, move a little closer to you. This is the guy who's on. No, it's not for the court. Somebody's recording.
Oh.
I know you were coming, so.
Good morning, may I have the name of your court, please?
This is Judge Thornton from the 11th Judicial Circuit of Florida.
Good morning, my name is Kathy, and at this time, there are no attorneys on.
There are no attorneys on.
No, sir.
It was going to be Jonathan Canov.
Yes.
Have we heard anything from him? Have you all
I just heard that he was attending by phone.
But not confirmed, I just heard that might be.
He hasn't dialed in as of yet.
All right. Who else is anybody else here on behalf of Dream Builders?
I'm here for Dream Builders, Craig Lewis.
All right.
He's Diablo.
Can't represent
He's
Diablo.
Diablo.
Yeah. All right. All right. Well, thank you, Court Call. I appreciate it. We'll talk tomorrow.
Yeah.
All right.
Okay, thank you, bye-bye.
All right. We're here on Cohen versus Dream Builders 17-197. Let me have appearances, please.
Good morning, Your Honor. Victor Diaz, Van Diaz and Partners for the plaintiff, Candace Nicole Cohen.
Good morning, Your Honor. Ari Sweetbaum on behalf of Rains and Straws.
All right.
And Craig Lewis for Dream Builders and Christian Schmidt.
Okay. All right.
Be fairly
Let me hear from
straightforward,
you.
Your Honor. I think to make things orderly, and you talked a little bit, Craig just arrived, there's a motion for leave to file an amended complaint by plaintiff. This would be a third amended complaint. This would realign third-party defendant Rains and Straws as a defendant now being sued by plaintiff. They had been brought into the case
Right.
by the builder, and there was some discovery taken in the case, and so now plaintiff is asserting a direct claim against Rains and Straws, represented by Mr. Sweetbaum. No other causes of actions in the complaint have changed.
We don't have a trial date as of right now. Is that correct?
We do, Your Honor.
We should.
When is it? Well,
That's
let's put it
what
this
I asked for
way.
a case management conference.
Yes.
It probably will
Yes,
affect
please.
it.
Right.
We have a trial date, the
If we
3-week trial
did,
period.
if I grant this, we don't.
Right.
So
It's the 3-week trial period, May 6th, and plaintiff is aware of that.
no, there's no way. Based
No.
on what
Right.
everyboody telling
No.
me and what I've read here,
Yeah,
there's no way.
correct.
So
I haven't even mediated, Your Honor.
No, it's correct, Your Honor, and my client is aware of that by moving for leave to amend.
And I'm
she
not going to
probably loses
oppose
trial
the
date.
motion for leave.
okay. All right. What's you don't have?
I'm not
nobody-
going to oppose, I'm going
He's the one
to,
that's
I am going to file a motion to dismiss, but I'm not going to oppose at this
Thank you.
juncture.
Okay, that's,
Yeah.
I agree with you. I think
Yeah.
that's the way to do
Yeah.
it too.
Yeah.
Okay, all right. So I'm going to grant your motion for leave to amend. Mr. Diaz, what is,
And then I asked for a case
has it
management.
been, did you, you attached it to the motion,
did,
did you
Your
not?
Honor.
Then I'm going to deem it filed as of today's date. How much
Okay.
time do you need as far as answer?
20, Your Honor.
20?
Yeah.
Okay, all right. You got 20.
Thank you.
All right.
Okay.
Oh,
So
for
then-
for a response.
Yes.
Okay.
Yes.
thanks.
Then both the existing defendants, prior to my filing the motion for leave, Dream Builders and Diablo has filed a motion for extension of time to do their expert witness disclosures, which if plaintiff filed for expert witness disclosures, but if you're going to move us off the May 5th trial calendar, those motions become moot, and we just...
I mean, there's, you know, based on what you all have put here, there's just too much stuff that needs to be done between now and that date. So I'm going to
That's
take it
fine.
off. I'm going to, you know, I'm going to strike that trial date. What I would ask is that you all, in the next week or so, get an agreed scheduling order together. I mean, you all can do that
Fine.
because, you know, including
Mr. Cano.
yeah, right. So, you know, talk with him, come back to me, submit in under proposed orders in Word format, a proposed scheduling order. Let me look at it. What's realistic as far as what you think a
Sometime in
realistic
the
trial
fall of
date
this
is?
year.
I think fall, like in a
Yeah, fall of this year.
mid-September as a date or October.
All right, let me just look real quickly because
I mean, we
I'm gonna-
have done a lot of discovery, but there will be some new discovery.
What's your number?
Yeah, it's definitely not a line of this. Lengthwise, we have to finish it one more day.
Give me time.
All right. Here's what you're looking at. Either October, because I've got August, and that may be a little bit too aggressive. So the next one I've got is October 14. Well, I take it back. Technically, it's October 15. October 14 is Columbus Day. The courts are open, but the clerk's office is not. So, we're not going to get real far as the jury's concerned on that. So it's going to be October 15.
Is that a 3-week trial
three-week
period?
trial period, yes.
Sounds good.
Okay.
Let me
Okay.
add one wrinkle if I could, Your Honor.
Yes.
You want us to prepare, I'm sorry.
No, you go ahead.
Just to clarify, you want us to prepare a scheduling order working back from that date?
Yes.
Okay.
Yeah. I mean, well, let's put it this way. So long as you all understand that if I sign it prior to your response and this technically being an issue, there's a waiver, and
Yeah.
let's not be.
None of us practice that.
We all
Okay.
get along.
All right, good. Okay.
And we wouldn't do that, Your Honor.
All right, so October 15 is going to be the trial date. But what
The
else?
wrinkle is, and we would intend to enforce it, is that we actually have a waiver of jury trial on our end with the plaintiff. So I'm just logistically, just something to bring in front of you how we
Okay.
would.
Well, I will say, I set whether they're jury or non-jury during the same 3-week trial period.
Okay.
Now, don't get me wrong. I mean, I'll probably, because I can work through, and
There'll be a jury
I'm not one of
trial,
those
and there'll
judges.
be issues that'll be tried by the bench.
Right.
Right.
So we'll,
Okay.
we can take care of
Just
that.
wanted
There
to
won't be a
bring it up.
problem. Okay. Yeah, we've done that before. So okay. Great. Thanks,
Okay, I'll
guys.
prepare orders now.
I appreciate
Thank you
it.
so much.
Thank you.
All right. See you all.
Stay dry.
Yeah. Yeah.
Do you want these returned back to the?
Please. Yeah, thank you, Victor. Judge, we really don't have anybody else.
Okay.
What number are you, sir?
Number 3.
Are you ready?
I'm ready.
Then let's go.
Good morning.
All right,
Your
good
Honor.
morning.
Number 3, D'Agostini versus Roulon. This is a motion.
Thank you, sir.
Is this your motion?
Yes, Your Honor.
All right.
It's a motion for summary judgment.
No, I read it.
However-
I'm going to grant it, but with 50 in place of 126. Okay. And so the number comes out to 90,483.62 is what I looked at. So
And just so I can understand why the lost profits are, I can explain to my client why I'm not getting lost profits.
because that's I don't believe those are liquidated. I mean, I would, if we were going to do this, well, let's put it this way.
And
There would be, I think that would be a matter that I would resolve at a trial.
okay. I did
Okay.
cite the case law that said, and it's in my motion, that you can award unliquidated damages at summary judgment, and that was in paragraph 8 of my motion.
Right.
And that's a recent third DCA case, which says any claims for damages liquidated or unliquidated, or for attorney's fees and costs, can be decided by summary judgment. That's our.
I agree with you. That's a claim for damages, and I would say yes. I find in your favor, in that regard. But if we're going to go to damages, that's going to be a trial. I mean, if you want a summary judgment at this stage, I'm saying that it's 50 in that place.
Even notwithstanding the third DCA case. from-
Yeah, but I read it differently. Yes, I understand what you're saying. I just read it differently than you do.
Okay.
Okay.
So I did prepare 2 orders, one would be.
Just in case.
Just
All right.
in case. One would
All
be
right. Well,
liquidated.
send me your JIC, your just in case order.
Yes.
Okay. Thank you.
I just have to make sure I have the right one.
Okay. Take your time. Take your time. What else, Arthur? What
You
else?
can do number 26. Who's number 26? Come up, please.
Pazos and Geico.
Judge, we have 26, only the defendant checked in, and we do have a court reporter for that case.
morning, Judge.
Morning.
I actually just spoke with plaintiff's counsel and he believes we were rescheduling the hearing.
Oh, okay, because I got to tell you, well, all right. I mean, it's also an awful lot on a 5-minute motion calendar unless you've agreed to 3/4 of
We
them.
have not.
Okay.
That's just a court report, and I think.
You tell me when you want it reset for, and I'll do that.
Okay.
All right. Maybe. Well, you still have to coordinate it with opposing
With
counsel.
opposing counsel.
Okay.
Okay.
Yeah. All right. Sorry about that.
It's okay.
Especially after driving here in this nice weather. Is there anybody else remaining in your case?
No, Your Honor.
This closes it out.
Yes.
Yeah.
Yes.
All right. All right. Then yeah. All right, what else do you have, Arthur?
Judge, the only other persons we have left is the couple sitting right here, the per se.
Okay.
The attorney's in front of Judge Rubel, and the young man in the back, he's the third party for that.
Which number is it?
That will be number 24, Your Honor. Bye, take care.
Did you call me a young man, or was I dreaming?
Oh, it's Orth. Oh.
You must think of me every time it rains, Judge.
That is true. That was a heck of a case. You know what? Let's as soon as he gets here from Judge Rabol, you know, let's wait let's wait a few minutes.
Yeah, because he just called the office when he took the bench saying that he apologized that he was in front of Judge Rubel.
Okay. All right. What else? Anything
And
else?
there's another attorney that checked in number 25.
Okay.
And he also went to Judge Santavania, but he's the plaintiff, but he's the only one that checked in so far. But
Okay.
he did say that he might be coming back.
He might be coming.
Yeah, because he said the attorney called him and there was something, so I'm not even sure.
Oh, okay. All right.
I think they're trying to do something like cold call, but where you also get to see the judge and the thing.
Oh,
Trying
really?
to create that.
It's experimental.
Yes, that's exactly. Victor, what's the case with there's a big case you have?
Pretty confident, Diaz. I mean, you already had typed in the date, you know, when it was at the order.
No, did it? No, I wrote it in.
One more.
Big Bugliero, it's still on third district.
BJ.
Yeah, it's still on appeal.
Okay.
3 copies?
Yes, please.
How long before that? That long? Wow. And how long before you think they come back?
Arthur,
Yes, sir.
as soon as you know, as soon as either one of them are back, let
Yes,
me
sir.
know.
I will stay here.
I'll come right back.
Absolutely.
Okay.
Yes, yes. So when you think they'll come back?
14 months.
That's a good case for you.
I know.
I think it's a strong case. All rise. Okay, please come up. Thank you.
Good morning, Your Honor.
All right, morning.
I apologize. I was the one who was running behind.
Oh, this is just, that's an outrage. You're in front of another judge, you know, I mean,
Thank you
get your
very much.
credit card out, not your, you know. All
I'm not
right.
sure you want it, Your Honor. I don't do it much good.
Good point. All right, are you all, this is on Theory
Yes, Your Honor.
and Martin versus Valon. Okay, we're here. This is case number 18-33570. Theory versus. Tell me how do I pronounce it? Is it Malav, and Viviana Galleto? I mean, all right.
That's good. I think that'll work.
Close enough. All right. Let me have appearances, please.
James Terry, plaintiff pro se, Your Honor.
Marina Martin, defendant pro se.
Okay.
Eddie Frank on behalf of the defendant, NC, Your Honor.
All right.
I represent the other defendants whose names are hard to pronounce.
All right. So,
This is Management Consulting's motion to dismiss the amended complaint.
yeah.
Yes, Your Honor. We're here on a lot of the same issues we were here on the first time around. I think our motion speaks for itself, but if Your Honor would like, I can.
It does. Here's what here's what I'm inclined to do. So talk me off the ledge, okay? As far as improperly seeking punitive damages, I agree. I mean, you can't do that at this particular stage, and it has to be done by a separate motion, and there has to be a proffer of evidence that has to be done, and so it's a completely separate thing. So I can't, that is out. The punitive damages are out. As far as seeking attorney's fees, you can't do that under these circumstances either.
Well, we actually hired an attorney before.
What's that?
We did hire an attorney before.
No, I understand, but the only way you can get attorney's fees is either by contract, in the contract itself, or by state statute. And you have neither in this particular case. All right, so so that's out. Number 3, but as far as legally insufficient and failing to state a cause of action, I got to tell you, I'm inclined to deny it at this stage based upon the redrafted complaint that I see. So, so talk to me, tell me why I'm wrong on that.
Sure, Your Honor. It's our position that if we're going to answer this complaint, we need to know what exactly it is that we're defending. It's been alleged that it's been a breach of contract, when our name, if at all, appears once vaguely in the entire proposal, which is, I believe, 3 to 4 pages. If it's going to be some sort of other action, we need to know what exactly it is that we're defending. I don't think it's going to be a breach of contract, but if that's what they want to pursue, they need to be clear. I don't think this is, and I understand Your Honor's position, especially being down here for the second time, but I just don't believe this is a complaint that we can answer, at least not in fairness to my client.
All right. Well, in unfairness to your client, I sadly for you, I disagree with you. I think you can answer this. I am going to respectfully deny the motion to dismiss for failure to state a cause of action. What I'm also going to do, however, is I'm going to order mediation. And I want mediation done within X amount of time. So let me hear from everybody on what X ought to be.
Your Honor, I would like 60 days to conduct discovery. I haven't done any discovery pending the outcome of this motion.
All right. Well, discovery, I'm not sure what else would need to be done. Well, let me ask you this, because I don't want mediation to be a waste of time. And the mediator is going to need to have, some facts in front of him or her. So, let me hear from you. What do you believe needs to be done?
Well, thank you, Judge. Defendant M&C is arranged to take depositions on the 18th of April. So
of whom?
Of both of us.
Okay.
So presumably we would want to do mediation after that, so that all.
Oh yeah, no, I'm not going to do it shorter than. I mean, that's 30 days, so I'm not going to.
I would like to have time, sir, to prepare some interrogatories to send to both of the defendants and give them time to answer them. So 60 days, I think, is more than sufficient.
All right. So you just need some answers to interrogatories. What do you need to do, if anything, for a mediation? I'm not talking about ready for trial.
No,
I'm talking mediation.
I think this takes us back to our original, and I don't want to readdress issues, but I'm not even sure where they're going, Your Honor. And I guess we'll have a better picture once we have their depots. But and if they're going to send us interrogatories again as well after that, I don't want to state something to Your Honor now and then have to come before you again without knowing. I understand you want to resolve this and get it moving quickly, and I think we're on the same page there. If Your Honor wants to set a date and then be open to us coming back once we've received their interrogatories and or taking their depo, with the possibility of maybe pushing it back, I think we're okay with that.
All right. Mr. Orr?
Your Honor, I have a pending motion to dismiss that wasn't noticed by the defendants. I don't know that I need any discovery beyond what counsel's already said, but...
Wait. There's you have filed a separate motion to dismiss?
I did, Your Honor. Two of the things you've already ruled on, that's the punitive and the attorney's fees.
Okay.
What I'd like, I don't know if you want to hear it now.
Do you have a copy of it?
I have the one my own.
Wait, hold on, let me,
No, we'll see, look at it.
you know what, let me bring it up. Oh, you got it.
That'll show you the filing date.
Okay.
I don't know, do you have the amended complaint in front of you today?
131, yes.
Okay. And the proposal attached to it?
And the proposal, yes,
They attach a proposal and
Correct.
and assert it's a contract.
right.
I mean, some of the problems are it only appears that one person signed the proposal on the last page, if it even is a contract.
Yeah, but that's, you know, that's sufficient to get past a motion to dismiss. I mean, you know, if
Well, there's
we're
two
talking
plaintiffs.
summary judgment, that's one thing, but,
But they don't allege whose signature this is. They haven't alleged that the conditions preceding have been met. Some of their provisions as to, as to their claims in the complaint, who did what work, who said what when, there's run-on sentences. I think that from memory, since you have my copy, paragraph 14 is contrary to the proposal.
you do say that here in 2E. All right.
And, is the proposal a contract? Begs the first question, and who signed it, who entered into it?
Judge, may I be heard?
But they do allege that, that there was a contract that was formed, and then they attach that.
Right,
So,
so
I mean,
the
so there
contract-
needs to be discovery that, that can be done, and you're taking their deposition. And that's an issue that, I would look at as far as summary judgment is concerned, but not on a motion to dismiss.
Well, under
So-
the Harry Pepper rule, the attachments that contradict the allegations of the complaint nullify the complaint. For example, in paragraph 14, they say, we didn't tell them M&C contractors were going to do work. Look at the sentence immediately above the signature line. Specifically says, work will be performed by VGM Decorators, Inc. and M&C contractors. So,
Well, but it doesn't say, it doesn't say that, M&C is not going to be involved. I mean, I see where you're coming from. But on the one hand, on the other hand, I got to tell you, I wish you all had a lawyer, because if you had a lawyer, then a lot of these issues wouldn't be coming up.
But
I
I
agree.
say something,
But, no, that's all right. You're winning. You're winning. I wouldn't say anything.
Pull the permit.
I'm going to respectfully, I'm going to respectfully deny your motion to dismiss, Mr. Worth, and say within, how much time does everybody need as far as answering?
the normal.
20 days. I'll give you 20 days.
Your Honor, just one thing we haven't touched on. Our motion is
It's granted as to the punitives and the attorney's fees as you ruled
correct.
before.
Yes.
is the amount of compensatory damages, Your Honor, that in their complaint. State's payments were made totaling, I believe, $64,000 and change, Your Honor, and they're seeking $100,000 or in excess of that compensatory damages.
It doesn't. I mean, that's, if they're alleging it's in excess of 15, 100 is in excess of 15. If that's what their allegation is and you file a summary judgment on that, then on that discrete issue, then maybe we'll see. But, all right, you all were going to say something about attorneys or not?
No, sir, Judge, I was just going to say thank you for denying the motion. And to say that
I'm just doing my job.
we're
Mr.
ready
Chairman.
and willing and able to go to mediation.
Okay. I'm going to order mediation within 90 days. All right. I would rather have it sooner, but if you all are going to do some minimal things, can you all reach an agreement on who a mediator ought to be in this case, or do you want me to?
I'm sure we can. We can reach out to them this week, I guess,
Okay.
or early next week, and see if we can.
The mediators I typically use are too expensive for this case, I think.
Okay. I mean,
I don't want to, I use Bob Dahlberg as someone in his firm, but they run,
Right.
$450, $500 an hour.
okay. Well, all right. Well, it's also going to be split between the parties. So let's. Well, you all, if you can't reach an agreement, let me know, and what I'm inclined to do. What I would just to let you all
mediation
know.
cost 50 plaintiff, 50 defendants, or is it a third?
No, in this case, it'd be a third. Okay.
Different
So-
judges have different rules.
Right. So, what I would normally do is I'd probably appoint some former judge, as a mediator. But the truth is, I'd rather have you all agree upon a person, because if you all agree upon a person,
I'll
nobody
get together with
can
counsel and we'll
complain.
send the theories 5 names
Okay,
within the 20 days to answer.
that'd be great.
Okay.
Okay.
Thanks,
All right.
Judge.
What else? Anything else?
That's
No?
it.
Okay. Thank you all.
Thank you, sir.
Thank you.
Judge, we have one more left, number
Please.
25.
If he needs opposition, I'll do it just to warm up.
Oh, it's unopposed. I'm going to sign it. That's true if I sign that order. Yeah. Who's going to send it? Somebody's going to send in the agreed order, but not. Oh, she is?
Yes.
Is she? She's not a lawyer.
She is.
Oh, she is a lawyer. Oh, okay. All right. I was thinking maybe.
And they're going to handle this administratively.
Perfect. Okay.
Because it's a hearing situation.
Okay. All right. Okay. Good. Thank you. All right. This is 25.
Yes, it is, Your Honor. This is Tuari versus...
Is it your motion?
It is our motion.
What do you hear from the other side?
The other side texted me, Your Honor,
And?
said that the son, which is, I believe it's Elon, I'm sorry, but he was involved in a very bad accident. He's in ICU in Arizona. Wanted to know if we could do an agreed order for 15 days to get a response, and I said the 15 days...
To response or to give the tax returns?
He wanted responses, and I said we would be agreeable if it would be a response with the tax returns, and he said that was a problem because respectfully, taxes would be relevant only if the judgment was entered and not prior.
Okay.
And
Let me hear your argument as far as why what is the relevance of tax returns in this case?
Well, Your Honor, with regard to the tax returns, our client has been, he's a taxi driver. He was, let me back up a little bit.
Give me the underlying facts of the case.
Yes, Your Honor. Our client is a taxi driver. He's involved in an accident with the son, and I believe it was Elon. I'm not sure if it was Elon or Izar.
Okay.
The son, according to their responses, was not an authorized driver of the vehicle. Now, they don't have insurance. They let the insurance lapse. The wife is a Florida barred attorney, and the husband is the only owner of the vehicle, says that the son was not allowed to drive the vehicle. They live in Florida. The son goes to the University of Arizona, and yet there was an Arizona tag on the vehicle. They're claiming that they have no money, and we believe that in order to get this case resolved, we would need to show that they do have a source of income that would be significant enough that it could at least, we could settle this case without having to worry about not receiving anything because they don't have insurance. That's our argument. Opposing counsel disagrees, and he wanted to appear by phone. I told him that was up to Your Honor, but there was no motion for a telephone hearing here. So,
I mean, what you're telling me is the relevance is for settlement purposes.
the relevance is to determine whether or not they are going to be able to pay anything because their insurance, they don't have insurance in that, which is a violation of state law.
They don't even, they don't have uninsured motorists?
They do not have any insurance. They let their insurance lapse, Your Honor. Which is a problem, I believe, but that's not Your Honor's problem.
Yeah.
And they're just claiming that they have no money. The vehicle that the son was driving was, I believe, it was a 2017 or 2016 Range Rover, which is not a cheap vehicle. So,
I hate to do this, but at this particular point, I haven't seen sufficient proffer in order for me to make them give up their tax return. So I'm going to deny your motion to compel without prejudice, so that if there are other reasons, I guess the other alternative. Well, I don't know. They had said that they wanted to.
Opposing counsel wanted to
file something in writing, or
I'm sorry.
What do they want to do?
He just wanted an extension to respond to our motion to compel, but I believe that we're going to be getting the runaround. He's going to respond by saying, we're not able to provide that, or we object to the providing it, which is what they did initially. And so we are just going to get the runaround. I'll see you back again with regard to the same issue.
Well, let's put it this way. Now that I know, what the case is about, what the facts are, I can hear it if you file it again with different grounds and some case law that backs up, your request on a 5-minute motion calendar. And so whenever you want to set that, I'm happy to hear that. But at this particular point, I'm going to deny it without prejudice. Okay?
Thank you.
Thanks.
For sure. Have an order. Yeah, approach.
Please. So whose handwriting is this?
This one's mine.
I know. I recognize that handwriting.
Instead of dismissing, I just put that the attorney's fees and punitive damages were stricken,
Yes.
so that they don't have to file a new pleading.
Yes, I agree.
Thank you, Judge.
That's it? We're
There's
done?
such a huge calendar on the wall outside.
Oh, I know.
I was